recently had a couple come up to me at a presentation I gave saying we do not need an estate plan because we have put all of our accounts by way of beneficiary designation. Well, it makes me a little nervous for a few reasons, and let's get into that. But first, let me explain what a beneficiary designation is. So, a beneficiary designation is just that. You can designate a person on your bank accounts, your retirement accounts, basically any of your cash accounts. We can also do this in real property called a transfer on death deed. But essentially, what you're doing is putting name or names of individuals who you want your assets to flow straight to upon your death. So sometimes this is called beneficiary designation, often in retirement accounts. Uh, Payment on death or transfer on death designations for bank accounts, often referred to as POD or TOD. And this is, just like I said before, a direct line from your account to your beneficiaries. Often, all we need to do is supply a death certificate, and those beneficiaries can receive their assets. For real property in Oregon, this is called a transfer on death deed. And we file that while you are living. And when you pass away, again, we supply a death certificate, and the beneficiaries listed on that transfer on death deed receive the property. Now, the problem with real property, first and foremost, is in Oregon, there is a cloud on the title. So that means that it might be difficult to sell the property for your beneficiaries when you pass away. In fact, it can have this cloud on the title for up to 18 months. And this is specifically so creditors can get paid. Specifically, also the state, right? If you owed the state any money, if you owed creditors any money, they have up to 18 months with this cloud on the title to come after the sale proceeds. So when real estate isn't selling, kind of like right now, it does create a barrier to sale. The creditor issue is also why I don't love an estate plan that is primarily based in this beneficiary designation because creditors still need to be paid, taxes still need to be done. So, especially here in Oregon, if you have more than $1 million at the time you pass away, that is taxable, anything over 1 million. So, that means taxes need to get paid. If that money just flowed directly to, especially more than one beneficiary, then we're looking at needing to recover money from the various beneficiaries to pay all those bills, to pay those taxes. And sometimes what I have seen is the responsible child, the one who does the right thing, is often saddled with the burden of ensuring that these bills are paid, often coming solely out of their share and or us needing to go after the other beneficiaries to recover some of those expenses. So what I don't love about it is it's usually that responsible child that then covers the expense and therefore gets less of a share. Also, if there's any risk of creditors, we want to cut those creditors' rights off. We do that through probate or notice and or paying off those bills. Often when we don't have a formal process such as probate or even a trust administration, it can get hairy, it can get tricky, it can actually be more work on those beneficiaries or one or two of them than a probate or a simple trust administration would do. So, the probate nobody loves. It does take a lot of time. It can be quite expensive. But if you have the right assets, then perhaps a revocable living trust is the best way to get all those bills paid, all those taxes done, and the remainder to your beneficiaries in a timely fashion. Other issue is when we're just do beneficiary designations, oftentimes people are forgetting about the lifetime documents. That is the power of attorney, the advance directive, the revocable trust in some situations. Who's managing everything for you in the event you can't do it yourself? So, a solid estate plan not only protects you, but also eventually protects the people that you are leaving your assets to and protects creditors. So, if you have questions about probate or the revocable living trust, just estate planning in general, and you're here in Oregon or Southwest Washington, feel free to reach out to Northwest Estate Law. If you live in another state, contact a local state bar, or better yet, ask some friends and family for recommendations to an estate planning attorney near you.